Hey, this is Darius, and welcome back to Founders Unchained, the show where we sit down with founders, builders, innovators, and experts in the field to discuss what it takes to build a startup from scratch, what it takes to get investments, what it takes to scale a business, and many more. And today we have a special guest, Jekabs. He's from venture faculty, specifically specializes in investment law. And it's really a pleasure to have you on the show, Jacob. And I hope we're going to have really interesting discussion about the investments, about what actually startup supposed to know before we even go to the investors. So yeah, pleasure to meet you here. And for the people who don't know you, can you just, Jacobs, explain us what is your background, what you do, and the most importantly, how you can help startups?
Yes, thank you, Darius, for the introduction. It's a pleasure to be here. Yes, so my name is Jekabs or Jekabs. I'm a lawyer and advisor based in Riga. I run Venture Faculty, which is a boutique legal and advisory firm with a mission that goes beyond just closing deals. We generally want to contribute to growing the startup and VC industry here in Latvia and Baltics. Because the region is developing fast, the talent is definitely here, and ambition is also here. And we want to be part of building this infrastructure and ecosystem here in the Baltic and help everybody who wants to be part of this venture capital industry and ecosystem. Practically, it means we are supporting founders and investors across the full cycle, from first incorporation of the company through investment rounds, regulatory compliance matters, and also cross-border transactions and exits.
Can you tell me if you are focused on to the Baltic region, or you also can support, customers from, let's say, Western Europe, or from US, let's say, or from Asia?
We are concentrating, of course, in the Baltics and in Latvia, but we have experience and we have dealt with several transactions in the VC field, also across the Europe, UK, and also USA. So I would say we are also covering international transactions.
Just going back to your background, I really would like to understand how you end up actually working with startups and investments, in your career.
Yes, thanks for asking. Actually, it's kind of interesting story because I was thinking about engineering or legal or business side, and then I actually found a bachelor's program which dealt with both legal and business side, and then that's how I initiated my studies. And then I found out about, let's say, private equity in mergers and acquisition, and then I decided to go into this field, and I started my career actually in one of the biggest law offices here, and I was in a corporate and M&A practice group, and then I got all the insights from the big deals and the due diligence process and all process of the M&A transactions. And while I was there, then I understood that, okay, this is something that I really want, but considering that the Baltic market is quite small for private equity deals, then I was looking for new opportunities for new interesting fields. And then I found out about venture capital. And it was really interesting to see the difference between the big private equity transaction and investment deals compared to VC investments.
As you know, Jacobs, this channel is designed actually for the startups, for the community, which is going to build something, or we are building something, or they are in the process of getting investments, or maybe we are organizing some investment rounds. It would be interesting to touch, one specific point, which is related to biggest misconceptions what founders have about the investors. Can you share, your view on that?
Let me start from the, let's say, big topic for this question. I think it's the gap of the generation between the investors and the founders, because the founders are usually the young generation, the newest generation, let's say so, and the investors are maybe, let's say, some other generation that already had raised their own funds and made their own startups and businesses, and now they are switching to being actually the investors. So I would say the thing or the misconception about the founders is that they need to understand the difference between the philosophy between the investor and founder and life values. So they need to match these life values, how they understand the life, the business, the work, because of course during the change of time, the generations also changed, so the people have different approaches to the business, to work, to relationship between people. And considering all digitalization of our world, I think the current challenge is maybe at the digitalization and actual relationship between the founders and the investors, and how they make this relationship really true and valuable.
Jekabs, I really would like to understand, how often you can see the founders who really understand the importance of investment documents, which needs to be in place, in order to get the investment.
This is a good question, but I would say usually founders really need the money, so they will do whatever it's necessary to get this fund. So if the investor asks for documentation and investment documents, they will say, of course, let's do it. We need the money. We want to proceed with our business. So of course that's important, but I would say it's not the matter maybe that founders usually focus of, because they're more focused to make this new relationship with investors, to understand also what the investor thinks about their business idea, if it's doable, if it's maybe approaching the market in the right way, the product is good. And then if there's such interest of investments now, or maybe potentially later when they have developed their product further, and then of course, once they have this agreement with the investor to proceed further, then of course it's really important to proceed with the documentation and investment agreements and shareholder agreements.
Okay. And in practice, who are preparing those investment documents? Is it like the startup founders working on that documents to prepare it, or it's basically delivered by, investors?
Let's say that it may depend. The usual situation is that, let's say, founders need to take this on their task list, and usually is that they approach some lawyers that could assist, because of course it's better for the founder to concentrate on the actual business and not to waste time on preparing the documents that maybe afterwards will be rejected by the investor because it will not correspond to the market standard. But of course, there's some kind of situations where investor is coming forth and saying, okay, let's agree that we will prepare from our side because we have also partners of law offices or internal legal counsels. And they can prepare and then ask founder to check on their side or consult with their advisors if that's acceptable to the founder.
There is a saying that investments has rules. So can you explain, what kind of rules it is and what founders actually need to focus on when we discuss the investment with the investor?
Yeah, I would say there's like different kind of rules. Let's start with the basic rules that maybe are the rules in the process of itself. So it's how you approach investors, how you communicate during the due diligence, and how you follow up. So it's the business ethics rules that are in the business. Then, of course, there's this legal layer, what the law provides and says about company governance, company operations, compliance. So these are the basic rules that are set, and it's quite hard maybe to change them. And then, of course, there's this layer of contractual rules. And these are, let's say, one of the important rules that are to be agreed with the investor during the process of the investment round. So it's basically how your relationship and on what terms, what obligations, and what rights you are agreeing to be in kind of relationship with this founder. So you are, let's say, concluding a contract for relationship with the founders and the investors in the investment process.
Do you know any other like unwritten rules what actually founders supposed to know?
Let's say the unwritten rule is that the relationship is the most important, right? Because you can agree contractually on everything, but in case everything will be in a bad position or everything goes down, then whatever you have written, it might help or might not help. So the unwritten rule is that the relationship is the most important.
When the founders were basically getting the chance to get the investment from investor, we feel so excited. So in most of the cases, we are not reading this agreement so carefully, and maybe not just because we don't want to read it, let's say, or they are too lazy because we just want to get the money. But sometimes, I don't think that we have competence, to read such a documents. So I heard a lot of examples when some investors we actually provided a document which has some specific clauses which is very beneficial for the investor, but it doesn't mean that it might be also beneficial for the startup. So could you share a couple of examples, of the clauses where the founders should really keep the focus on?
Yeah, definitely the founders, what they need to really understand is maybe the practical aspect of the terms, rights, and obligations that apply to them from the let's say, most simplest clauses that could be are information rights that usually investors are requesting to protect, to have some transparency, what's happening inside the company. So the practical example would be here, it's like the real obligation of what kind of information, how regular, in what kind of format that the founder needs to report back to investors. Because of course, if the clause provides that the founder needs to do it on a weekly basis, it's requesting a lot of time for the founder, and then the founder loses this time while he can actually focus on the business itself. So it's important to, let's say, navigate between interests of founder and the investor, and to understand how to make them fair and proportionate. In case of information rights, of course, it's important to be transparent from the founder's side, to let investors regularly know about updates and progress, fulfillment of KPIs, and also the financial statements and information. So investors are also on the same page what's happening, and maybe how investor could help the company in case there's something going on that is slowing down the business, because founders sometimes would not have this experience that the investors have, and they could help actually the founder. So it's important always, for founder to remember and to understand practically also what it means for them. So what kind of obligations the founders needs to fulfill and what it takes from them. Another point maybe is regarding the governance aspect. Who sits on the board? Who needs to decide on different kinds of matters regarding the business and business operations? So the founder needs to understand the flexibility of the decisions that founder will be able to take. Because of course, the investor is interested that the most important questions related to the business and operations are also approved by the investor. So it's important for the founder to understand whether the investor's control is not burdensome for day-to-day business decisions, such as concluding employment agreements with regular employees and concluding regular client agreements. Of course, it's normal that matters that require consent might be some qualified employees with higher salaries, and maybe some other transactions overseeing some kind of a value in terms of money.
You was mentioning, Jekabs, about your experience working not only in Baltics, in Europe, but also with US companies. What is the difference comparing Baltic region law and US law, and do we have a difference between them?
Of course, there's huge difference between the Baltics and then Silicon Valley or other markets, because in the Baltics, the market is generally young. It's kind of still trying to find its shape. And for instance, the talent dimension is different here in the Baltics than in, let's say, USA, because we have much more less people here. People know each other.
Maybe a good point would be to touch, difference between regulation. We have completely different regulation in US compared with Baltics. Why this is important to touch this question, just because some people, we need to understand, if we do business in US and if we raise capital in US, there is some specific rules. And if we do business in Baltics and we want to raise capital in Baltics, there are some specific, also rules which are different from US. If you could actually explain a bit, what is the main difference, could be great.
In terms of difference between the regulation or legal scope between the Baltics and Silicon Valley, it's important to note that it's also kind of affected due to the maturity or the long period of the market that has existed in Silicon Valley compared to Baltics, because in the USA, they have developed a highly standardized ecosystem. They have standardized investment agreement, safe agreements, ESOPs, or employee motivation tools, the option pools, the milestone-based KPIs for investments, and standard templates of term sheets. So everybody is kind of using the same playbook also from the legal perspective. And the US is quite a huge market with a lot of startups and a lot of investors. So everybody knows one and the same aspect and legal regulation. Compared to Baltics, of course, we have a different kind of legal scope, regulations, and different kind of structures and tax rules. So it's kind of completely different market in terms of legal regulation, in terms of investments. Of course, there's similarities of, let's say, direct equity investments and convertible investments. But the main difference is that also the ecosystem is kind of different. The investors from Baltics are expecting different kind of protection compared to US, because it's clear for everybody in the market that venture capitals are taking the risk, and that in case they invest, they're mostly not expecting to get the money back, because from 10 investments, probably one of the startups will be alive after 5 or 10 years and be potential to provide exit and return some proceeds for the investor. Compared to the Baltics, I would say the industry is kind of more skeptical regarding this. They, of course, understand the risks, but they are some kind of more protective.
I spoke with many investors in the past, and what we said, we have a specific mindset. We understand that every single investment what we're going to do, most likely 90% of that investment is going to fail. And we understand that, and we do accept it because they are basically like venture capital. So we are taking the risk and trying to find this, unicorn size company which can grow so massively and it can pay off, all the losses what we gain throughout the journey. Like 90% of the deals are actually losing the game. Only 10% of them can be successful. And those successful deals, actually, we are making profit for venture capitals.
Maybe another point to add is, of course, also that the market is much more smaller, right? The startup amount here is much more less than in USA. So the investors are more skeptical in choosing which startups to invest. Yeah, in the US, the market is so huge that you found the best ones of the best one. And then, of course, your maybe risk appetite is much more less compared to the Baltics or other markets.
And in terms of founders and agreements and investments, what are the 3 questions what normally startup founders we need to ask before we sign term sheet?
This is really good question. I believe maybe there's not specific 3 questions, but maybe 100 of questions. But let's concentrate on the most important ones. I think that most important is the question to understand of who you are actually getting into the relationship with. Taking investment is kind of marriage with the investors. So you are committing to each other for like several years. Also through good and difficult moments, through agreements and disagreements. So it's important to understand and ask, like, who are you actually getting together with? Because in our modern life, it's marriage is not so strict anymore. Like everybody thinks that it's easy to get divorced, but in terms of startup and relationship within investors, let's say this marriage, it's not so easy because in case divorce, then it's kind of leading to the death of your company. So it's really important to really understand and ask questions that could help you to understand with whom you are actually entering into the relationship and business partnership.
So what you say basically with that, it's not all the money is good money, right? So you need to be careful from where you take the money. Okay.
That's true. Yeah. Yeah. The second kind of a question would be also regarding the control and governance of the company. So how will the company's decision making will actually work? What will be the control of the founders? What will be the control of the investors? How they will each help each other to move this business towards success, and also how they will build the trust between themselves to make the hard decisions, right? When there will be moment, the opinions will not be aligned. So how will they resolve this? And I think the third question is also about the obligations. So what kind of obligations for the founder are set in the term sheet, or what kind of obligations also are set for the investors? Because if the founder is looking for some kind of active investor and wants really a help from investor, then of course it's also important that term sheet provides some kind of obligations from the investor, that it will be involved in the business. He will try to help, to give the contacts, to advise on the strategy, or provide some other guidance or assistance. So I would say also it's important to really understand what kind of obligations are already set into the term sheet.
Yeah, and everything what you said right now, and specifically speaking about the third point, I think it's so important. Sometimes, people can trust each other, verbally. Investors told them that we can help them, support them, and we also are selling themselves too, basically saying that we will do a bunch of different kind of things for you guys. We will support and help you. But reality is when you sign agreement, get the investment, it's really hard to get the right support from investors too. And if it's not written in the agreement, I think the startup have no right actually to push investor to give this kind of support. And this is the reality. Startups are selling the idea. We're trying to sell all the value propositions, making this the best deal. And investors, from on other hand, also we are selling themselves, saying that we're going to be massive support and help. But reality is that none of them are helping each other too much in most of the cases.
Yeah, that's true.
Jacob, speaking about the type of investments, Specifically speaking about the equity, when it is a right choice and when does it quietly hurts the startup?
I think it really depends. And the question that needs to be asked is for the founders, like, what do you need beyond the capital, right? Because equity makes most sense when the investor generally brings something beyond the money. So it's the network, the expertise, the doors that are otherwise closed for the founder. So in case you really need the help from investor, it might be more beneficial that it's through the equity. And of course, it also depends heavily on how many fundraising rounds are you planning or expecting. If you are only raising one round, then of course it's maybe doable that you are doing only the equity round, right? But in case you are considering several rounds over several years, then you are giving multiple dilutions and a governance impact to your company across every future round. Then, yeah, you need to evaluate what kind of future plans do you have and what do you want really to achieve with the investments. Where the equity hurts, it's mostly the governance and the dilution to the founder. Because, yeah, if you maybe bring many small investors with small stakes and end up with a cap table where nobody is generally engaged, then you are maybe actually reaching to the situation where deadlock happens. So you cannot adopt decisions quickly, or there's like some kind of veto rights for some investor or shareholder. Or also, it's really hard to get some kind of small investor to sign the documents that are really necessary for you to proceed further with the business and the decision. So the control angle is also important.
What I noticed based on my experience and working with multiple startups, if the startup really value his project and his business, we normally don't want to give a lot of equity. By looking to this, you can sometimes feel how motivated, how startup founders actually values their company. You can see many projects which I would classify as average projects, right? We have some use case, maybe we can grab some small piece of market, and we can still do some kind of business, but it's not going to be so massively profitable. So what I see when those guys are raising capital, we are giving 30 even percent or 40 or even 50% of their equity to the investor, and we don't care about the future too much. I see other examples when founder values his company a lot, and sometimes he's raising like even 1 million, 2 millions, but he's giving away only 5 or even 3%. So he's giving like 3 or 5% of his equity for millions of dollars. So this specific point shows me that this founder actually values the company, and the company actually might have something really valuable, and it can be massive or scalable business in the future. Another thing is what I actually learned working with startups, that majority of pre-seed companies, we don't think about the dilution too much. And it happens later on in their lives that after, let's say, 5 years, we end up with only 3% of equity shareholder in the company at the end of the day. So this kind of startup founder, he will be not motivated anymore to run their business, because there is no point for him to do so. All the shares already disappeared and belongs to somebody else. So I think it might be good advice actually for the startups to think what kind of investors you are bringing in and how much of your company shares you are giving away at the beginning, because later on it will be important.
Yeah, I fully agree. And also, I can add from the practice that I have experienced also that there are some situations where actually founders have diluted a lot considering like the earlier rounds. But going forward, it's like there's possibilities how to deal with the situation and increase the founder's stake back. Sometimes it's requested also for the investors in the next rounds. So they offer the opportunity to increase the ESOP and the option pool and to provide some kind of part back to the founders to increase their stake. So there is situations, where it can be bad, but it's also possible to resolve the situation later, because the founders can never predict the future and the rounds actually in the terms. So it's definitely important nuance of the dilution, but it can also be resolved.
Yeah, so this is exactly why it's important from day one to consider a good package of documents having in place, because with the help of people like you, we can actually secure themselves, we can protect themselves, and basically we can produce the agreements at least which can secure them in the future, and we can buy back the shares.
And also important that the founders are in good relationship with you, that they are also motivated to give you back some compensation, right? Because they believe in you and in your possibility to exercise and to implement this business idea and to move the business further. So they believe in you. So they are also like ready to give some kind of back equity to you to motivate you to move forward.
Okay. Jekabs, safe convertible notes or priced round, what actually is better and what founders should consider, in your opinion?
Yes, the honest answer is that it also depends, right, on what stage you are and what are you expecting, as already we mentioned previously. In terms of these investment types, of course, the safe is one of the most simplest and fastest instrument that was also developed in the USA, especially from the seed stage when it's necessary to get the financing fast and move fast further. And it's also quite founder friendly because it's designed that the money is given and it's converted only later in the future. So the investor doesn't come immediately on the cap table and doesn't receive all the, like, let's say, statutory rights of the shareholders. So it's kind of a really good instrument to do and secure fast investment. But of course, it's important to note that, like especially in the Baltics, so we have a quite problematic with the safe investments due to the local regulation, and that regulation has not adjusted some nuances in order to implement the safe here. Of course, I have found situations where founders have used the safe templates from the USA and haven't changed anything and used here locally with some, let's say, angel investors, maybe some other investors that haven't put attention a lot of the regulatory aspect of this. So it must be reminded that, you need to consult and check in the local jurisdiction if the safes are recognized and actually can be enforced afterwards. So the investors also are protected. Regarding the convertible loan agreements, of course, it's also kind of a little bit a different investment type because, of course, it has an interest rate on it and also it has a maturity date compared to safe. Safe usually doesn't have a maturity date. It just converts on the future event, which is the fundraising mostly. And for the CLA, it's maybe not so founder friendly and it's more investor friendly due to the interest rate. But practically speaking, convertible notes and agreements and safes are, of course, much more lighter in a process than the full equity or equity round. Because in terms of equity, depending on the jurisdiction or in Latvia, it typically requires like notarization or commercial register fillings and also full negotiation of the shareholder agreements and other agreements or even a deep due diligence process requested from investor. So in short, CLA and SAFE is definitely a tool to secure investment more faster than equity in most cases, but also the difference is for the investor protection because of in case of SAFE or CLA, the investor doesn't get the statutory shareholder rights, but in case of equity, they receive the shareholder rights. So it's also coming back to the question, so what is the purpose and what is the result that founder really wants to achieve with the round? If he really needs to secure money fast and doesn't want that there's a lot of involvement by the investor, then of course CLA or SAFE can be used. But of course, if he needs involvement from investor, then the equity could be more preferred. And in terms of CLA also, or the convertible note, it's important to add that of course, it's like a loan, so it needs to be evaluated for the company. The convertible note can be preferred in case where the company sees really that it needs the money fast and that in the future, in the financial positions, the company will be able to earn back the money together with the interest to repay and get even more money on top of that. So they would not dilute or give the possibility on any new shareholders to come, but just to use effectively the money to repay and earn for the business.
Okay, thank you for this clarification. It's going to be very interesting for my community to know. When does it make sense to take a loan or venture debt, for the startup? Because this is also like an option. Can you explain that?
Yeah, let me start with that. In reality, most of the founders maybe do not fully think about it, but getting like traditional bank loan as an early stage startup is most cases really or extremely hard or even impossible because the banks lend proven businesses And of course, startup is not a proven business yet. Yeah, in case of venture capital debt, then venture capitalists understand the startups and the risk need for the money, so they give on based on more preferential terms for the business, the loan. So it's less bureaucratic, more founder friendly, and the lenders actually understand what is the risk that potentially the loan will not be repaid back.
Okay, so do we apply some kind of requirements for the startups? It's not just only we are giving the money, we still need to have as like basis as a requirement, what the startup needs to cover, what kind of requirements we need to cover in order to get this debt? Or is it like, it might be also available for the pre-seed companies too?
Yes, of course, it depends. From experience, I can say that mostly it happens to the cases where the startup can really prove the increase of the business and the value by getting this loan. And also, usually the loans are tied to the KPIs and achievement. So the loan, let's say, it's set to be disbursed based on tranches on the monthly or quarterly basis, that companies need to achieve some kind of next KPIs in order to get new money in addition. And then on top of that, also the investors usually secure that in case the startup cannot repay the loan, it will be possible for the investor to convert it to the equity and to become a shareholder.
When the startup founder should refuse the personal guarantees, in your opinion?
This is really interesting question because in the VC, I believe it's really not a standard for the founders to give any personal guarantees because it's, of course, everybody understands that it's a risky industry. As I think we already previously touched upon, only 1 out of 100 founders usually proceed further successfully with the company. So if the founder really gives a personal guarantee, it's really huge risk for the founder itself, and the founder really needs to understand what kind of personal guarantee it is providing and what's, let's say, his financial situation and assets and how can it affect also his life. But also from the other side, usually the founders are very young individuals that, let's say, have this possibility to risk because of course in case it will go bad, then there will be a new possibility to make the new startup and to build another business. I think there's statistics, and then usually founder only with its third business proceeds successfully, or that the success rate is significantly increasing from the first. So I would definitely advise to consider when somebody offers the personal guarantee, because it could lead to the conclusion that potentially this person does not really understand. And to add, also, I think in case founder receives proposal that the personal guarantees are required, then it's really necessary to consult and maybe consider that maybe this investor or party is not really a venture capitalist, because it's trying to avoid from the risk that venture capitals should take, right?
Okay, and I remember once I spoke with one of the clients, and the problem he had, he got like 20 million worth of real estate, and he wanted to get the collateralized loan, basically using his real assets. And for some reasons, banks were actually rejected the application. So do you know why it might be? What is the reason for that?
Yes, I believe it's the situation with that banks like standard businesses. Yeah, I think because the banks want to really see the business that is stable, that is ongoing, that is producing revenues, that has history. And in case of a startup, it's just not their risk appetite. They are not providing the loan because your business is too risky for them. It's less likely that you will be successful, and this is the risk that the bank is not able to take, right? And that's the reason why we are in the VC field and why they are venture capitalists, because they believe in this industry. They want to help the founders. They want to help the industry because it increases the innovation in the whole world, and they are ready to take this risk because it will help the ecosystem and the industry and the technologies to develop.
Yeah. And another thing is that venture capitalists will normally have a higher risk appetite. Jekabs, probably you know that in crypto space, at least, you can still see investment rounds where the people actually sell the tokens. What do you think about this? Is it really good option? Is it actually legal option to do so, at least in Baltic region?
I think this was actually a huge topic back in 2024 and 2005, but I think, the market is kind of different now. I think even if we look at the crypto industry and crypto market now, it's like having some kind of difficulties due to the MiCA and other regulatory aspects and also the market as itself. And I think also it's like getting harder to get listings on the exchanges for the token issuance. It's harder to make the token issuance itself. So I would say it's kind of getting a complicated process to get token raises. And as I have seen and experienced, that more people are now switching back to the regular equity and the tokens are kind of not really preferred at the current market conditions and the complexity of all the listings, exchanges, etc. And from other perspective, also it's important that the tokens differ. Like each company can make their own kind of a token, so it's also harder for the investor to really understand what kind of token it is, what kind of rights it will get, and how it will work together with all the project. So it also makes complexity for the investor. That's also, I would say, a reason why equity is now more preferred option.
I know that we're a bunch of startups. We actually are trying still to raise capital for our tokens, but I know from venture capital perspective, nobody wants to invest into the tokens anymore. So you actually can see the options or proposals from the startups that we are offering you equity plus token warrant. So this is like a new structure, what we are trying to build. But normally tokens, we have no value at all until we will be listed somewhere in the exchanges. So, investors, we may sell the tokens and this is how we can get additional value. But it's not like it used to be 4 years ago when all the crypto market purely was raising capital, selling the token. And right now it's not like this anymore. And I think people who will be watching this episode, if we are from crypto space, and if we want to raise capital, don't waste your time on token sales because it's not going to work for you. This is my honest personal advice.
Yeah, and I think like investors are becoming more skeptical because they understand like in case the project goes bad, in case to get something back, it's more possible to do it through the equity than the token because due to all the legislation and regulatory aspects, it's quite hard now to navigate in each of the countries how each national court and legislation will actually understand the tokens, like their protection for the investors and the actual possibility to get some kind of liquidation preference for the investor back, some other rights.
Would you agree that it was like really interesting concept, right? You are selling the token, which has no value in company ownership, let's say. Having the tokens, you have no relation to the company equity. It's not belongs to you. You have no equity, no shares, no nothing. And you cannot control the company where you invested to because, you have just only tokens. It was like ideal concept for the startups to get capital and give nothing back to the investor in the shape of shareholders or equity. So that was amazing concept. It used to work a lot and it worked good, really. Many projects actually raised millions of dollars doing so. But right now, I think with MiCA, as you said, this new regulation coming into place, and it actually classifies all the tokens, what type of tokens might be, and what every single player issuing tokens or distributing the tokens we need to have in place as a license, what kind of requirements we need to cover, and so on, so on. So those rules, it's not really good for the startups, but I think in general, in long term, the new regulations introduced will be really for good in the near future. Jacob, speaking about the stages of capital raise, the first initial phase is like pre-seed round. And normally you can get the capital from family, from friends, from other early supporters like angel investors. In your opinion as a lawyer, what is the most safest way for you to raise capital in order to secure the relationship after all?
This is really good question because in the early stage, like the persons that will invest are like the 3 Fs: the family, the friends, and the fools from the legal perspective. But not only, I think it's really important, that the founders are really transparent with these persons and family and friends and also other investors, that they're really transparent on their aim their business and to explain in details that it's high risk investment and support, and that's most likely that it will not profit. It's less likely that the founder will be able to compensate back this money back, and that's also important to save the friendship and the family relationship, and maybe also like trust with the other co-founders and angel investors investing early. So I think it's really important to be really transparent with these people and explain in details and not to overpromise something from it. And of course, from the legal perspective, it's important to conclude some kind of agreement with them where this would be explained, and then they would recognize that, of course, this investment is risky. They understand and they are ready to take this risk. And also, I think it's important for the founder to explain the risk for the family and friends where this investment could be potentially really essential for their personal lives, for their financial situation in their personal lives, so that it doesn't affect badly the friends or the family, that they make this investment with their last funds available and then suddenly they understand, oh, what we have done. I don't have the money now to, I don't know, to purchase the car or to pay for my children for the university. That's more important than the investment. So yeah, I think, of course, the documentation is important, but I think the transparency is the most critical part.
Jekabs, can you tell me also, what do you think about the fundraising agencies? You can meet a lot of companies who, suggest to the startups to sign the agreement and start working on the fundraising. At least what we state that we can raise capital for the startup. So what do you think about this option specifically? Is it good support in your opinion or not?
I haven't used such one, so it will be hard to comment on this, but for my personal belief, I think it's a good option definitely to check out. I think there's no harm in that, to try it. I think it's important for the founder to understand that, of course, it's not possible for anybody to promise that they will be able to find the money for you. They will be trying to do it, but of course the founder need to understand there is no guarantee in the market, right? Because market is developing, that the investors are developing their strategies, and then maybe yesterday the investor would invest, today maybe not. Yeah, the political situation changes, as we have seen recently. So I think there's many aspects, and the most important is just that, yeah, you can use such opportunities because it definitely can save time for the founder, but nobody can actually guarantee that, yes, come to me and I will definitely find you the money that you are raising, right?
I agree. Nobody can actually tell you that tomorrow I'm going to get you $1 million, just because you don't know what is the mood of an investor. Maybe, as you said, the strategy was changed. Maybe the narratives changed. Believe me or not, but, majority of crypto venture capitals, we used to do a lot of investments into the blockchain projects and infrastructural, the PIN projects and so on. We migrating to AI field. You can find some of investors who actually don't really invest into crypto anymore. We just basically focus to AI. And we just change the strategy as we go. Nobody can promise you, anything. We can do the job for you, we can try, but there is no promise here that we can bring the result, at the end of the day.
I think also it's important for the founders to understand that the fundraising really depends actually on their own side, right? Because like these advisors or persons that are assisting, they can help you to make these connections with potential investors. But in the end of the day, the founder will be the one that needs to close this deal, right? They need to sell the idea of the business. They need to prove that they are the real founders, that they can trust them, and that they will be the real person that can execute their own idea. And I think that's the most critical part.
Yeah. So the heavy job needs to be done by you as a founder. Anyway, yeah. Okay, so Jekabs, based on your experience working with multiple companies, specifically in seed round, what the first-time founders gets wrong?
I think it's a good question. So I think there's a lot of complexities that maybe they don't think, and if there's like the first founders or the founders of their first startup, I think the most complexities are that they don't really understand the complexity or the process length of actually doing the seed round. Because it can take 6 or even 12 months. So it's not really fast process, I would say, because the more later stage the company gets, I think the lengthier the process is for the investment crowd. Also, I think they do make mistakes all the time and get something wrong in the process, because it's the way how the founders learn in the process, how it helps them to also develop their characteristics and knowledge also in the market and making the relationship with the investors. So I think also some kind of potential issues is that they are not well prepared for the process. They have not maybe prepared the data rooms with all the documentation that may investors ask and that could prolong the process. Maybe they have not defined for themselves what they really want to achieve, what are the terms that they are like already trying to offer. So the process would be much more faster because the investor already like sees the offer from the founder, not vice versa, because it happens from the side of investor, then of course the founders needs to review, then it also needs to evaluate and consider the already existing investors and how they really want to protect the existing investors and their relationship. So I think that also takes a lot of time. So it's important for the founder to consider the relationship between the new investors for themselves, the new obligations, and what kind of rules and terms they are ready actually to accept on.
And he was mentioning data room. This is like magical word, everybody speaks about this, but I'm not sure if, early stage founders will understand what actually is in the data room. Can you just elaborate really quickly, what kind of documents are supposed to be in data room?
Yeah. From legal perspective, in the data room, always investors want to see all the commercial and corporate documents. Regarding the corporate, they want to see all the documents regarding the entity that it is established, the registers of directors, the registers of shareholders. So they want to really see the current picture of the company and then the shareholders, investors. The second thing would be definitely the cap table and also agreements associated with the cap table, which would mean, which is warrants, options, and also other investment agreements such as safes, convertibles that are like not currently converted but are existing, because it's important for the investors to see and understand what will the cap table look after the round and what will be the actual stake that they will receive. Also, they want to see and check the previous round valuations because they are mostly discussing in the negotiation also the valuation, and they want to see that what has been told about the previous rounds actually corresponds to what has really happened. Then of course, regarding the founders, it's important to see the relationship and the contracts between the company and founders, also regarding their salaries, that they are also transferring and assigning all the IP rights, the non-compete clauses. It's also important. Then, of course, the most significant or most essential commercial agreements with the clients or partners or developers, etc., and the key personnel, and of course the IP rights as itself and the assets, what the company is holding, owning, and is it really owned and held by the company, and that it's not maybe using some kind of other personal assets or trademarks or IPs, right? That, let's say, they want to really understand the situation of the company, about the relationships, and that everything is managed inside the company, because of course there are situations that the founders haven't yet concluded agreements or some kind of asset, since the incorporation is still owned by the founder personally, not the company, etc. They want to really see all these aspects in one folder where all the documents are listed there, so it's easy to see the documents and understand what's inside the company and what's the company doing. But of course, if we are not touching the legal side, then of course there is also different financial side where definitely investors also want to see all the financial statements from the company. Also, regarding the product itself, it could be some kind of code or something related to the product and prototype of the product. They also needs to be ready to provide demo, etc. Yeah, so I think that it depends on the company and what it actually does, because also the list of the documents and matters that need to be inserted depends on that.
So it looks like very sensitive information what you need to disclose to the potential investor. In this way, providing such a information, you can actually leak your data to the investor who not necessarily going to invest into you, and maybe he even can use this data and pass it to the competing company, which is already in the portfolio. Because startups, we never check the portfolio before we going to speak with investor. This is a common mistake what I can see. Before startup goes to investor, we need to double check the portfolio companies in the website somewhere or somewhere available in public, just to see if there is no competitors companies in the portfolio. If this is the case, I would strongly, maybe personally, would recommend startups to consider to sign NDA documents with investors. What would be your, advice at this case? How to protect myself as a founder to make sure that we're not going to leak the data?
I think it was really a good note, and it's really essential for the founders. It's definitely necessary to conclude NDAs before providing the data room to the investor. And of course, it's essential to understand what kind of investor is it, and whether it's not some kind of competitor trying to get your information through showing that it's kind of investor, etc. Yeah, so it's important to understand what the other party is. Regarding competition, I would say, of course, it's important to understand if the other party does not really intend to use it, but it's important to founder to understand that there's a lot of investors that invest in the industry, and sometimes it happens that they have several portfolio companies that could be partially or potentially competing, but it's not a bad sign completely, because it's possible sometimes that through this investor, it's possible to get better insights in the market and also integrate these two businesses together in different ways. So it's just necessary to understand really what this company is doing, or the investors' other portfolios, what is also the control, and then to evaluate if the founder is ready to take this risk and if there's some kind of added value for the company, the startup.
So everybody who wants to get assistance on NDAs or some investment agreements or help on support with that, Jekabs, he's the right man to help you out. So I would like personally to ask you, how do you think? Is it better to work with the big investors, which are very famous, popular, and get a bigger amount, but with a bad terms? Or it's better to sign with a smaller, let's say, tier 2, tier 3 investor with a clean term sheet?
It depends, as similar to other questions. It really depends on the situation. Like if the founder really needs the money urgent and there's no other possibilities, of course, it's on the harsher terms. It might be doable because you need the continuity of your business and to move further, and it's no time to waste. Or if you waste the time and don't get the funding, then it's subject to certain risk that company might die as well. So it really depends. I believe there's no one answer to that question. I think it's important for the founder to really just understand what are like consequences or the risks or the obligations arising from the situation, if it's like a big investor with a harsher terms or smaller investor. Otherwise than that, I think there's not straight answer. Is it bad in one case or is it worse in other case?
Speaking about the bad terms, could you give us a couple of examples? What kind of terms might be considered as bad ones?
It's important to understand which side are you representing, of course, because bad term is for one party, while the same term is a good party, good clause for the other party, right? So it depends from which side you are looking, because if it's from investor, then you are trying to protect the investment. But if you are looking for the founder, you are trying to protect founder.
Maybe we can touch like the startup side of things, because investors, they are investors. We have capacity and we have budgets in place, we have financing to secure themselves, we have lawyers and so on. But in most of the cases, we speak about the problems which startups are getting, because normally we're trying to bootstrap, we have no cash, we have limited amount of money. If we are receiving money from family and friends, normally it's like small amounts. So we don't have capacity to invest into the lawyers. And I think it would be interesting to hear the story related to founders, what we should actually know as a bad terms and what we should expect in the agreements, and how we can protect from those kind of things.
Yeah. I think in terms of bad terms, the most critical ones is the governance of the company, because it really defines what is achievable and how the company can progress or act in case of uncertainty or events that are not really possible to expect, right? Because on daily basis, the business receives or gets situations that they haven't expected and that need to be resolved fast in order to move further. And it's important to understand what kind of restrictions are in place in terms of governance and decision making that can potentially affect this accordingly, also the company or the financial situation. So it's important to understand what kind of, let's say, reserved matters or in simple words, matters that require some kind of a threshold or other party or other investor consent are defined, and how they practically could apply, and also what happens in case there's like a deadlock situation. So in case there's this matter but you cannot agree, and how to proceed further. Also, from the founder perspective, it's important to understand and check the good, bad, and bad lever terms, because it really affects what happens to the founders at the moment where something happens to founder, or founder decides to go away from the company. So it really needs to understand what will be the effects on him. So he will potentially lose all of his stake, or he will be able to keep some kind of small stake, or if he has some kind of non-competition restrictions for 12 or even 24 months, etc. Also, I think that's important from perspective of founder to really understand the consequences in case he decides to exit the company early, because of course no founder really expects to exit the company or go away, but it's important that it's defined in the contract and it's agreed with the investor, because when the situation will come, it will be already too late to agree. So that's also maybe one and most important reason why it's really important to get some advisor or lawyer to help in this process, because they will know the regular aspects that need to be agreed today that will significantly increase, that will help to later to resolve the future issue that nobody maybe predicts currently.
Yeah, so you need to foresee things in the future. You cannot do things just blindly, you need to think ahead, especially with a business. If you are starting business, you need to think, what kind of business you would like to see after 5 years and 10 years that will give you the vision and strategy. And later on, you also need to think that life is life and risks are happening, problems are happening, and you may have multiple problems like related to investors. Maybe we will start to force you to do something what you don't want to do, or maybe we will completely change your strategy and this is not the thing what you are believing in and you don't want to do it. So I agree with you. And actually that was a really good point about the exit clauses to describe how you as a founder can actually exit the company just in case if something goes not according to your plan. So thanks for sharing this. It's really valuable insight.
Yeah, I think also one last aspect to add on this matter, I think it's important also to agree on the exit of the company like together, because usually the founders are really tied to the startup because it's kind of their baby, right? And they are not willing to let it go at some moment. And then they really need to understand and agree with the investors, because investors are willing to exit the company and earn from that, right? And then it's important for the founder to really understand that although he maybe wants to keep the company for a longer period of time, at some point of time it will be necessary to do the full exit together with the investors, either he wants it or not.
Okay. Do you know how long it takes this investment cycle? How normally it takes for the investor to be in the business until he will exit?
Yeah, I would say like the standard length for usually investors is like 5 to 7 years, because it's due to the fund structure that the investors are usually structured, because they have the limited partners that provide the funds, and the limited partners are the ones that are expecting that return within 5 to 7 years, and that's the reason why the venture capital fund afterwards is pushing the company to do some kind of exit, because they need to go back to the limited partners and provide this money back to them. But of course, it depends on the VCs. It can be also 10 years. So it's important to also understand and discuss this aspect between the founder and investor. And of course, also another aspect that it's important for the founders to check also for the investor if it's ready to provide like follow-up investments in the next rounds. Because sometimes it's valuable to get such an investor that can actually follow up with additional investments in the next rounds, so that it will support also in the next rounds, that they don't have limited resources maybe for only the current time being and the current round, but actually that it can be involved in several rounds that can like help the startup.
Okay, that's interesting. It's actually a good option to consider, to ask an investor to be as a potential follow-up investor. And ideally, if we can add this information in the agreement, that would be awesome. That we are committing to invest again in the future rounds.
Yeah, regarding this point for the commitment, it's usually hard. I don't know now if I have experienced such situation that they are really committed, but usually how it's done is that also investor is asking for some kind of compensation for that. Either it's kind of an options in case they're investing in the next rounds, or also discount. So founders need to maybe understand that it's also normal situation that the investor comes and says, okay, I'm going to invest now. I also would like to have some kind of a discount in the future round, or also super pro rata, right? So basically that he can invest more than he's proportionally owning at the current time being. And I think it's important to understand that like in the standard business industry, it's not usual to get such discounts or help the company to raise money in the next rounds, because the new investors will see that the existing investor is still believing in the company and still believing in the founders and providing this follow-up investment. And also, yes, that the founder can trust the investor that they will get some kind of support in case of a bad scenario, right? If they will need some kind of a bridge funding before the finalizing the round, because maybe it was extended in the process and it's taking more time than they expected, but they need the funds to be alive. So it can also help a lot.
How I, as a founder of a startup, should know which lawyer to choose at the beginning of my business? Do you have some specific keywords or words to look for when I'm searching for the lawyer?
This is a really, really good question. I think there is no direct answer, because usually in the market, it's like reputation of the persons and the lawyers that you get from some other parties that you know, or other persons or other businesses or other founders or even investors, right? So it's really good, I would say, to try to reach out within your network and to understand if somebody within your network knows some good lawyer in the industry. And then I definitely suggest that this person has worked in the industry, because there are some kind of nuances in the terms, etc., that are different from the, let's say, private equity or companies that are at enterprise level getting revenues, etc., because it's completely different kind of risk, etc., and different kind of a market. So that's one suggestion. And also in terms of current industry insights, the AI is a big topic, right? And I think also it's important to founders to understand that, of course, it's really, really good tool to use, and I really recommend it, founders to use it, because it's a good first reach to understand and give the analysis to AI to understand and give their insights. But of course, we need to understand that the AI currently is like a doctor, but it's not willing to able to solve everything, and it's not able to analyze to the best level. So it's important, to involve also the lawyer that knows. And it will be interesting also to see actually the future of the lawyers and law offices providing the help to the startups, because it will be really essential that the speed from the lawyers, and also it will be important that the lawyers also will be fast, that who use the AI and can be efficient and provide the top quality. So it will be also really interesting to see within the market how this will change. But for the founders, I really think it's important, to use the AI, and also to get some really good lawyer that is also founder friendly, and also that I think has the characteristic that wants to help the company, and not only earn money for itself, but really help and explain in the details to the founder the terms that are offered, and not provide the answer that no, this is not recommended, you definitely should avoid, but rather than explaining and saying, hey, this is the terms, like this would practically mean to you this and that, and consider that from the business perspective, and if you are really ready to approve it, right? So I would say that this lawyer has like different kind of perspective of communicating with you, because I have seen in the practice that there are some kind of lawyers that are really strict with the founders and really saying, no, this is like too much, you cannot agree to that, right? And that really destroys the actual potential investment, and the founder goes away, and the founder like remains without the funds. So I think it's good that there's like really good connection, and they can be transparent, and that the founder really understands what's on the risk, and then that he can decide whether he is ready to get this and accept this risk on the terms.
Jekabs, it was a very, very interesting discussion with you. I really appreciate that you came to our episode. It will be massive benefit for the community who will be watching this. Thank you very much for joining. I really appreciate that, and I really wish you good luck with all your business, what you do. I hope in the future you're going to support some good startups and you're going to help them and support throughout the journey. So just in case if somebody will be interested what we discussed today, you can always reach out to Jekabs, and Jekabs will be able to help you out. So yeah, thanks one more time.
Yeah, definitely. And thanks, Darius, for inviting to this session. And I really hope, that I was able to give some kind of useful insights in the market and some kind of legal nuances in investments and investment rounds and types. So I really hope, you all enjoyed. And it was a pleasure to be here.
Thank you very much for your time.